Good evening, everybody. This is the regular meeting. Today is, excuse me. It's the regular meeting of the Planning Commission. Today is Tuesday, December 14th. The time is 7:01. I'd like to call the Planning Commission meeting to order. Let's first start with roll call. If we would just state our name coming down the line, please.
Nicole Davison.
Jason Diebel.
Michelle Williams.
Kirk Scott.
Tom Fitting.
Richard Jordan.
Thank you. And if everybody could please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Are there any additions to the agenda or changes?
I have one to move. I would move that we add under new business the request for the release of bonds from Jason Pizzaglia, owner, Paz Construction LLC, for 249 Upper Patagonia Road and 41 Scott Road.
And that's going under
New
new
business.
Is that a motion?
Yes, that's a
Do I
motion.
hear a second?
Second.
Okay, thank you, Ms. Davison. Any discussion, comments? All in favor? Aye?
Aye.
Aye. Opposed? Abstain? Let the record show we're going to add that under new business. And now on to the call for public delegations. Public delegations is the time when the public are invited to speak to the commission about certain matters, items, referrals, or applications. Items, referrals, or applications subject to a decision by the commission, a public hearing, or in litigation may not be discussed. During delegations, the members of the commission will not be directly able to answer questions. Is there anybody here to speak to public delegations? Okay. Moving on, communications, Mr. Gaishel.
I have none at this time.
Thank you. Zoning representative. I went to one of the meetings. I went to the November, well, I didn't go to it. I have details about the November 17th meeting. There was another one. I guess I'll talk about the one that I went to.
Certainly, and I think Rich.
Well, I attended the November 4th meeting, I think it was, but there was the one about the virtual gun was postponed because they didn't have enough public notice, so there wasn't really anything on the agenda.
Okay. And then the November 17th one, there was a application for Viking firearms, and there was quite a bit of discussion about that and subsequent newspaper articles, and that application was eventually approved.
Yes.
Yep. And I think that's all they did at that meeting that I'm aware of. So ex officio, Mr. Salerno was
He's gone.
unfortunately no longer going to be our ex officio, and I've heard that it's going to be Bill Weber. So we look forward to working with Mr. Weber. Planning Director, Mr. Gaishel, do you have anything for the commission?
Nothing at this time. There was the one matter regarding emails, if you would like.
Yep,
Commission members, if you want to, feel free to talk. Commission members could get a town email address for, $5 a month. It's an option, kind of separate your personal email from your business.
It makes it convenient for, in the case of Freedom of Information requests. So they have one place that you can collect all of your emails. If you're not doing that, then I recommend for sure always CC Mr. Gaishel or Ms. Lindo with all communications, so there's a central collection point should we need to get FOIA for any reason.
If I may ask, how do we proceed with getting this
Details will follow.
Yeah, I would just contact me, tell me your interest. I'll pass that on to the first selectman, and they will pursue obtaining, I guess, addresses.
Thank you.
Okay, so that brings us to subcommittees. We have the Plan of Conservation and Development Implementation Committee. Michelle?
Yes, so while we have had a busy 2021, our meeting schedule got off kilter a bit. As you know, we were intending to meet every other month prior to this meeting. However, with various cancellations and conflicts, we have not met in a bit. So what I would like to do now, if possible, is adopt, or I don't even know what the procedure is, but just set the next subcommittee meeting so that we're all set for January. And I believe that we are able to do this at this meeting because this is a subcommittee of the Planning Commission. So if it pleases the group, I'd like to go ahead and set a calendar date for our next meeting, January 25th, 2022, to start at 6:30 prior to our 7 p.m. Planning Commission meeting. January 25th.
I think that's acceptable. If we can generate an agenda and put it on the calendar, that would be a good step. And if we have to make some adjustments, which I'm thinking we might, we can always change the time or date for that. But as a first step, I think we should do that.
And we said 6:30?
Correct, yep. So a half an hour before this meeting. It's my hope that at that meeting, the subcommittee can decide what kind of schedule and cadence for 2022 works for them. But as a subcommittee out of this commission, I believe we are able to set that calendar date.
So as of now, though, it would be only Rich and Michelle from this commission on that committee. We had Larry.
We had Kirk too,
It was,
and then
Norm Peck.
Norm.
So we may, we could obviously reach out, send correspondence over to zoning as well, and indicate, if Norm still wants to stay on, or if they want to appoint someone else. It's their prerogative. Yeah.
do you have any other things you want to add to that?
No, I think I've updated this commission on the most recent activities of the subcommittee. Oh, actually, looking at my notes, I stand corrected. We have not met since I spoke to zoning on October 14th at their meeting. As you know, part of our implementation plan was to go before each board and commission and kind of reacquaint them with the document, talk about our steps for implementation moving forward. So I did have that opportunity to speak at the zoning meeting on the 14th. We have checked pretty much everyone off of our list here of boards that we needed to meet with. There was not a lot of feedback from the commission members, but I'm glad that we were able to be represented and speak with them about it at their meeting.
Thank you, Michelle. Okay, so that comes to the chairman section, myself. Just thank you, everybody, for being involved and showing up and doing a good job. I appreciate that. And congratulations for being reelected, or elected, Jason and Tom. So that brings us to approval of the meeting minutes. Our last regular meeting was October October 9th?
12th?
October 12th. Has everyone had a chance to review the meeting minutes? And are there any corrections or comments? Do I hear a motion to approve the meeting minutes from October 12th?
So moved.
Thank you, Michelle. Do I hear a second?
Second.
Was that Tom or Rick?
Well, both.
Oh, okay. Thank you both. Any further discussion? All in favor, say aye.
Aye.
Opposed? Abstain?
Aye.
Let the record show 501. And we're accepting the meeting minutes. So that brings us to public hearings. There are no public hearings this evening, and that brings us to subdivisions and re-subdivisions pending. Mr. Gaishel, would you like to start us off?
Certainly. As we left things, the Inland Wetland Agency had not acted as of our last meeting. We were waiting on their report in order to take action and move forward with the application before you. That said, I'll just reiterate, it is a subdivision, not a re-subdivision. It's not currently subject to public hearing. The Inland Wetland Agency last night approved the application with several modifications to require a bioswale along the north side of Upper Patagonia Road in front of several of the lots. And they also required a 25-foot wide conservation easement along the south side of Upper Patagonia Road to protect the vegetative buffer along the beach area there and the lakefront. I did prepare a memo in response to receiving all of staff comment from Ledge Light, as well as from our town engineer, Alex Close. Basically, we were awaiting a final report from both of those individuals in the affirmative, which we've received and are part of the record. If you have any other comments, I'm more than happy to go through the memorandum that I prepared. The applicant is here. Certainly can answer any questions that you have thus far.
So have we gotten updated site plans or drawings and all
Yes,
that,
the record's completely up to date.
including the changes for wetlands last evening?
No, that does not include those modifications.
Okay,
Those are not shown on these plans.
okay. Anybody have any questions for Mr. Gaishel?
I would just like to state for the record that I was involved with the Inland Wetlands Agency when this was under review, but I was not a voting member as of the time this was voted on.
That's, do we see that as a conflict in any sense? I can't think of any.
I don't think it's a conflict, I just think I should state it.
Yeah, no, thank you. That's a good idea to be completely transparent. Yeah, thank you. Okay, so with that, I'm going to ask the applicant's attorney if you'd like to continue.
Thank you, members of the commission. Before I get started, I'd like to add to the record just a couple items on here. And first would be the report regarding from Sarah Sportman to the state archaeologist. I think there was a notation on the memorandum I received from Mr. Gaishel. And again, Chairman, I know I sound like a broken record on this, but I got it at 4:06 tonight. I have not had a chance to review it in any sort of detail other than the note that it appears longer than the prior memo that we've received with his comments on it. One of the items I think that was listed in there that I did see is the Sportman report didn't appear to be part of the record, so I'd like to make that part of the record at this point. Thank you.
And also, we've not had a chance to review that either, so.
Correct.
Okay.
Understood.
Yeah.
I also have with me Tim May from May Engineering and JP Marine from Marine Surveying, our engineering surveying professionals. And I will point out to us, before I get to the open space issue, I have subpoenaed Jeffrey Torrance to the hearing tonight. He was a member of New England National and Niantic Real Estate when these applications or these phase subdivisions originally started. If there are questions regarding the open space that I am unable to answer, I would propose to put those questions to Mr. Torrance, since he was involved in the very beginning of this, when a lot of the open space that was donated and banked was done through both New England National and English Harbor, my client. And I had an email from myself to Casey dated November 16, 2021.
And what is, can you describe what that
That's
is?
an email from me to Mr. Casey raising some issues on this and another issue I intend to get to as to whether or not Mr. Gaishel would need to be recuse himself from review of this. I might as well cover that right now. The issue there is on two prior occasions, one during one of the site walks, Mr. Gaishel approached me in the presence of my engineer, and then another one during a meeting with him and staff about whether or not my client would be willing to purchase or sell him and or one of his neighbors a portion of his property or grant a license agreement on that. And I related that information to my client, and as you can understand, my client was extremely upset about it because it raises the issue of a conflict all over the place, and it's also in violation of the East Lyme rules of ethics that somebody who is reviewing an application should not have an interest in the outcome of that application. And as I've indicated in the past history, we have routinely gotten staff comments late or at the last minute. And the email at 6:45 tonight was essentially the last straw for my client, saying, no, this has got to stop. We've got to bring it to the attention of the commission, and ask that he not be involved in this application any further. It is simply to the point where we can't feel that we are getting fairly treated in terms of the way the process has played out here. As you'll recall, we were here a couple of months ago with regard to the lot line revision that took 18 months, where Mr. Gaishel had unilaterally denied that lot line because of town agent review, which hadn't been received. And so my client was penalized for that, even though they had no control over that, and had made the application to the Lyme Health District. And so, as I said, it's simply just the last straw as far as my client is concerned at this point in time. And I had a discussion with Mr. Casey about this momentarily before the meeting. I'm sure he can advise you on it, but we would ask that, and I think the application is far enough along at this point in time that him being removed from the process is not going to impact this commission's ability to decide the application. It's really, as I understand it, the only issue is the open space, whether or not we're going to be required to provide open space, or whether or not, based on the history of phases of this subdivision, we will be exempt from having to provide any more open space, having provided 73%. I'll get to that in a little bit, so I don't end up being redundant. My next exhibit would be an email from Alex Close, the town's engineer, to Tim May, our engineer, regarding confirmation that some of the items he had questions on were cleared up. Because I don't think Mr. Close actually submitted, he submitted a report back to Mr. Gaishel with 2 items on it, but the report didn't say all his other concerns in the prior memo had been addressed. So I wanted to make sure that that's part of the record. The next item I'd like to submit is a email from Wendy Brown Arnold dated December 13th to Jennifer Lindo regarding the approval of septic review. Actually, I guess that can be part of it. That's the septic review. May already be in this. There were 3 exhibits delivered this afternoon: exhibit PP, QQ, and RR.
I think that's what he's talking.
Do we have more than one of those, of copies of those?
Yes, actually, the ledge light review dated December 12th is already in the record
Okay.
as Exhibit RR.
And I would note for the record that on the original submitted yesterday by Ms. Brown Arnold, there was a typographical error. It referred to lot 59. It is actually lot 58. She sent an email earlier, I believe, correcting their typo that was sent to town staff, and I was copied on it. If I may, I don't want to get ahead of Mr. Acacia, about this. So I'd like to just review briefly some of the issues that we've hit upon previously, because I know it's been a while. As evidenced by Exhibit A in the record, and Exhibit B and Exhibit CC, B being the original design report, CC being the amended design report in order to respond to staff comments. The application proposes to divide roughly 14 acres of the property into 8 residential building lots. As indicated in both the design reports, the remaining land is not proposed for any residential use, but it's going to remain in the same historical manner that it was at the time for the past 95 years, which was the campground. The applicant has received no comments from the zoning department as the plans are fully compliant with applicable zoning regulations. The applicant has received approval from Ledge Light, having demonstrated each of the lots is feasible to construct a 4-bedroom septic system on the property. The approval letter dated December 12, 2021 was submitted earlier tonight as an exhibit, as I've indicated. The amended approval letter was submitted to staff. The plans on this application specifically require the use of geometric GST septic systems. GST septic systems are the most technically advanced septic systems currently approved by the state of Connecticut and treat wastewater in a much smaller footprint than any other available septic systems. Those plans are also in the record. The town engineer has approved the application for stormwater management and erosion and sediment control plans, which are included in the record as Exhibit MM. The applicant has fulfilled the following requirements of the East Lyme subdivision regulations, obtained a permit from the Inland Wetlands Agency for activities in the upland review area, as proposed on lot 56 of the subject property. Submitted the National Diversity Database letter, which appears as Exhibit A in the amended design report. Exhibit CC is and Exhibit CC, the record is in the record. The applicant has also added a recommendation of the determination letter to the plans of this application regarding construction measures and for site-specific design protection, site design protection measures. Prepared and submitted a Phase 1B archaeology report by Sarah Holmes, which I just gave you earlier tonight, and that was submitted to the state as well. Prepared and submitted a sightline plan prepared by Kristen Clark, a licensed Connecticut PE, which provided clearing limits and fence removal to obtain the necessary sightline distances from the 3 proposed common driveways. The sightline improvements identified in sightline study will not only address the sightline requirements of the 3 common driveways, but would also address the dangerous blind curve that currently exists for non-motorized traffic, i.e. pedestrians. And what that does is we're clearing a portion of that road because there's no sidewalks there, so it will allow for a grass area for pedestrians to step outside of the paved roadway when vehicles are coming. Also, removal of the chain link fence will provide for enhanced safety when people are walking as pedestrians or bicyclists through the area. We received no further, shouldn't say, other than the memorandum received tonight, we haven't received anything else from staff, and I intend to address the open space right now. And it's my belief that the open space issues have been thoroughly addressed, and the position taken by Mr. Gaishel on this is just simply incorrect and implausible, essentially, in light of the history of this application. I'd ask the commission members, if you can, I know everybody has the laptop in front of them, turn to Exhibit EE, which is my November 5th letter of 2021, wherein I outlined the history of the property and included the relevant exhibits to this, or to that, in the letter. First, from the onset of the development of Nottingham Hills subdivision, the East Lyme Planning Commission was aware that the subdivision was going to be developed in a phase over an unknown period of time. In each phase, including the current phase 5, additional contiguous land was acquired. That is factually correct, but also demonstrates that the comments by Mr. Gaishel in his memo are incorrect, because this was not the phases 1 through 4 of the Nottingham Hills subdivision were not all acquired at the same time. It wasn't a single large piece of land. They were acquired and added to the subdivision as the client and its predecessor developed the property. This common plan of development is demonstrated as follows. In phase 1, the original phase of the Nottingham Hills subdivision, development consisted of 7 lots. That's Exhibit A to my letter. Utilized land that was acquired from Robert Blatt and formerly owned by Gene and Louis Bull. It noted that property shared that property, or this property that I'm referring to in that phase, has a common boundary of 2,200 feet with the Girl Scout camp. And it was noted by Mr. Gaishel that it did, but I did glean from the memo tonight that he has corrected that statement and indicated that it does. And it clearly does. It's on every subdivision map that we've had with respect to the applications submitted by my client. In addition, the area in my letter, I highlighted in orange the note on lot 6 of the boundary survey, which states land for future phase development. Finally, in regard to that, there's Exhibit C, is the open space covenant that deferred the dedication of open space until a future date, as is provided for the East Lyme, in the East Lyme subdivision regulations. So there's a memo from Attorney Block in that letter that indicates that an applicant who's engaging in a phase subdivision can reserve land, open space, and at the end of or the completion of the phases, then allocate that open space to a different area. The memo is included in the letter, and what it makes clear is that we have the ability to move the open space if desired, as long as we provide the appropriate amount, that we can also reserve it for future development. Phase 2 was a subdivision consisting of 46 lots, received inland wetlands approval, but encountered delays from staff. There was litigation with the town that ensued, and it resulted in the splitting of the property into future phases 2A and 3. A copy of the Phase 2 plan is attached to my letter as Exhibit B, and then I note that it has a common boundary with the Girl Scout camp. Referenced in Phase 1 is highlighted in orange on the Phase 2 plan. Phase 2A is the plan listed in Exhibit E, included and required the acquisition of additional contiguous land from Walter and Dolores Scott on April 18, 2005, and the Torrance Family Limited Partnership on August 14, 2003, to create several of the lots identified on that plan. In this phase of the development, 23 acres of land was deeded to the town of East Lyme, that's Exhibit H in the letter, for open space at the request of the former First Selectman Wayne Frazier, who was at the time pursuing an agreement with Yale for access over that property, the property that was involved in the open space and Yale's property for what's known as the Goodwin Trail. I've highlighted the common boundary on that in the documents that were submitted, and I noted that I would also note that this page on the approved plan included Lot 11 area designated as future phase development. Phase 3 was approved by the East Lyme Planning Commission in December of 2005 and included and required the acquisition of additional land acquired from Robert Blatt, formerly the estate of Jean Damo. I noted that the boundary of the contiguous real property acquired for this phase, Nottingham Hills subdivision, is highlighted in orange on page SD3 of the approved plan as provided. Phase 4, approved by the East Lyme Planning Commission on November 16, 2010, included the required acquisition of additional land from Robert Blatt. And so we understand that Mr. Blatt was the original property owner. He was also a member of New England National. He was part of the settlement with the town of East Lyme. New England National was obligated to assign its properties and development rights, et cetera, to another entity. And that entity would then have the right to continue the development phases of that. That entity ended up being English Harbor Asset Management. And that's where we are today. So we stand in a direct legal chain pursuant to the federal court settlement agreement of succeeding to the rights of the prior developer. As part of the approval of this phase, New England National and East Lyme Planning Commission reached an agreement wherein New England National provided a conservation easement in favor of the town of East Lyme on 10 acres of the land, despite the fact the subdivision had already met the open space contribution requirements, and provided, however, that the subdivision would bank or reserve the right to use the additional open space provided, in other words, those 10 acres, for any other subdivision that it chose to develop within that process. As part of the findings, the Planning Commission, in its approval of Phase 4 of the Nottingham subdivision, this is Exhibit P, approved the following language and agreement. Section 3.4 of the development, the proposed re-subdivision conforms to the Comprehensive Plan of Development, POCD, as adopted by the East Lyme Planning Commission as the proposed re-subdivision is located within a residential district adjacent to existing lots which were previously approved as part of a cluster subdivision. The proposed re-subdivision continues to follow the pattern of development characteristic of the existing residential cluster development. In addition, the proposed subdivision reduces the potential impacts on the water and soil resources by proposing low-impact development techniques for the treatment of stormwater and best management practices for soil erosion control. The applicant for Phase 5 is English Harbor Asset Management, who obtained the assignment, as I noted, of the development rights to the Nottingham Hills subdivision from New England National in March of 2020. Prior to commencing the subdivision of Phase 3, lots 19 and 21, prior to commencing the subdivision of Phase 3, lots 19 and 21, in March of 2020. And as you may remember, we were all involved in that subdivision application. As members of the current plan may recall, that was approved in January of 2021. Only developed, and it was important to note that's important to note for two reasons, because at the hearing, you may recall that some of the neighbors raised issues regarding the deed restrictions in there, whether people could re-subdivide their property. And we pointed out and submitted the documents that indicated that only the developer had the rights to further subdivide any of the properties. With regard to the acreage and the fact that my client is not proposing to donate any open space as part of this subdivision, Phase 5, I would submit that the findings from the January 11, 2021 hearing make it clear that we have exceeded, for the overall subdivision, by a significant amount, the open space that is required. One of the findings at the approval, as part of the approval in January 11, 2021, reads as follows. Section 6-7, open space, as demonstrated by the design report in Exhibit A, identifies the Nottingham Hills subdivision as being a division of 107.82 acres, and the open space provided totaling 41 acres. Based on the subdivision regulation requirements of 30% open space or 32 acres, the subdivision has exceeded the required open space by 9.1 acres as of the date of the pending application. Subsequent to the application, the applicant conveyed portions of lot 19.5 acres and a portion of lot 21, 1.27 acres, to the property that was in the process of being conveyed to the East Lyme Land Trust. And you may recall there was a significant parcel behind there. That combined 37.9 acres, which was transferred to the East Lyme Land Trust as of December 30, 2020. Upon recalculating the open space, it now totals 79 acres, 79.34 acres of the total subdivision, 107.82 acres. As such, approximately 73.5% of the subdivision's land is now in open space, where only 30% or 32.3 acres is required. So my client, as part of this phase development, has contributed already well beyond the required open space that the subdivision regulations require. And therefore, we believe, since this phase 5 is part of the existing phased subdivision, we don't need, as part of this application, to make any further open space donations to the town. And to sum that up, then, as reflected in the amended design report for the pending application, the proposed lots being created at 14.2 acres, which would require dedication of 4.26 acres if we were to be required. Since the subdivision has already provided significantly more, no additional dedication of open space is required for this phase of the subdivision. A memorandum from Town Council at the time, Mark Block, addressed to Gary Gaishel on February 1st, 2021, addresses the similar circumstance in another East Lyme subdivision and opines that no further open space dedication can be required. And I submit to you that the same is true for this application here with respect to that. The reason I indicated it was for the 14 acres of lots. We're talking about 4.2 acres. That's what would be required if this was a standalone subdivision and there had been nothing else done. But we are now, because it is a phased subdivision, well beyond what is required for the entire acreage. I'm happy to take questions regarding the open space. Anybody has any?
I believe that we will have some questions. Does anybody want to jump in? I think I have one to start. So obviously there's some legal proceedings happened and transferring of rights and, you know, the development, the Nottingham Hills development seems to have grown and grown and grown, right? And I guess part of my question is following and understanding when the end of a development would happen. And I'm just looking at this piece of property, and I'm trying to understand how it really is part of the Nottingham Hills subdevelopment.
Well, because it's contiguous to, and the other parcels, the other phases of the subdivision, as the client has gone along, have been acquired. This is not a subdivision where all the parcels, all the land is centrally contiguous to itself, if you want to put it that way. But they weren't all under common ownership when my clients acquired it. They were under ownership by various other individuals. And as my client developed one section of it, they would acquire the adjacent property and then continue to develop that. And that's been the plan all along. And Mr. Torrance is here if anybody wants to get the history of how those other, I mean, it's in my letter, but that's how. So we have phase 1, we have phase 2. Phase 2 runs into some issues, gets split into phase 2A and phase 3, but it's all contiguous property that we keep acquiring in the process, just as we are doing in this particular case. We have it under contract to purchase it if there's an approval granted.
So the argument is, as long as the contiguous property is purchased during the development of these phases, this could continue to grow unchecked, conceivably. We could have phase 100.
Well, I wouldn't say unchecked. First of all, any development requires town approval. It requires planning approval, zoning approval if appropriate, inland wetlands. So it's not unchecked. But as long as there is land there, right? Anybody who owns that land, if I've got parcel A that's 50 acres, and there's parcel B that's 60 acres, and I'm Tom Jones and I own parcel A, and Bob Smith owns parcel B, he's free to develop it as a subdivision too under the regulations. But I might buy it from him and say, okay, I've done 10 lots on my parcel, now I want to do 10 lots on his parcel. That's perfectly permissible. And what's happened here as this has gone on is my clients and their predecessors entitled have acquired a portion, then acquired the land adjacent to it, and continued to develop it in a pattern of development. If you were to go in there, you wouldn't necessarily know that at the beginning of this, the first 5 houses were on one parcel of land, the next 6 houses are on another parcel of land, because they're all part of a common development, residential development, and that's indicated in the report, that this is consistent with the zoning regulations in terms of it being residential, and it's consistent with the type of development that's occurred there.
So, excuse me, unchecked was not
No,
appropriate.
I know. I'm
You're
not trying
you're
to-
suggesting this exempts you from, or exempts the client from open space requirements if they exist at all, correct?
Well, the open space requirements exist, but we're saying we've already met them. And so as part of this phase, we're not required to give any more open space. Let's say there was 1,000 acres over next door that we wanted to develop. We might have to then provide more open space because we might exceed what we have banked. But we have banked 107 acres of open space. But we have the additional open space. In other words, in a subdivision of this type, phase subdivision, according to Mr. Block's letter, we put away what we need to put away. And so as we add parcels to it, we don't need to, at the moment anyway, provide additional open space because we've already done that as part of the phasing in of the subdivision. If we get to a point where the amount of land we acquire, and I don't know if that'll ever happen, there's a finite amount of land out there, let's be clear about that. We might have to then come in to the commission and say, okay, we're doing 20 acres here, 10% is 2 acres of land that we have to provide as additional open space. But what we're saying is, the calculation also is, frankly, is relatively small. So on 14 acres, it's 4.2 acres of open space if this was a standalone subdivision. But because it's a phase, and we've provided, notes here, 73, actually, I shouldn't say it's my notes, it's the commission's finding. We provided 73% of the required, or 79 acres. We don't have to provide any more as part of this phase of the subdivision.
Thank you, I understand.
Sure.
I think I have one more question, but I'll let someone else go first.
I do have a couple notes that I'd love for you to clarify. I'm sorry, I can't even hear myself, so. So you've made it very clear that the developer has always had a long-term plan that this would be a phased-in development with additional acquired lands coming to this commission in phases. But I'm unclear from your Exhibit EE whether there is evidence of that master plan from the beginning. And if so, I mean, this parcel would not have been included at that time, or was it referenced specifically?
No, there was never, phase 4 wasn't in the original. I mean, the developers went in, acquired a piece of land, and then acquired the next piece and the next piece, and continued the same sort of development there. But this is not a situation, I think that's what Mr. Geisha refers to. Well, they didn't have this as part of the original application for phase 1, therefore it can't be part of that. It's the whole point, because we don't control those properties, right? So we can't always be sure that we are going to get them, but the plan was to look at all the adjacent properties and say, we can acquire those, they're going to be part of this subdivision application process.
Right, well understood. So at the same time then, when you're dedicating open space in any of these phases and exceeding the required amount, as you do not know whether or not you will be able to acquire additional adjacent parcels and develop them as part of another phase of the subdivision, you are essentially, still conveying that open space in an unbanked way. I mean, the subdivision could have been complete at any time if you were not to acquire additional parcels. If someone else was to acquire this same parcel under different ownership, that developer would be subject to the open space requirements that you are arguing you are not, simply as the same owner.
Well, if this was a separate developer, right, unrelated to ours, then that person would have to meet the zoning regulations specific to that. But the language in the minutes of the prior approvals indicated that we were banking this, we banked 10 acres of land for future development. It specifically says that in the minutes. I can't find them right now, but they're part, trust me, they're part of the record. They're in my letter on that. And so this developer and its predecessor were distinctly looking forward, saying, we are continuing for future development. We will give you this land now, but we want to be able to apply some of it to future development, and hence we're going to bank it, and the commission approved that bank back in 2010.
Okay, I would love for this group to take a closer look at that, because I believe you that you're telling me it's there, but I'm not seeing it. I did have just a final clarification question for you, though, because you have referred a couple times to our previous approval at the beginning of this year with the re-subdivision of the existing lots. And I just want to point out and make sure that I'm clear on this, because many of us were here, some of us were not. That approval was dealing with already approved lots within the existing subdivision. It did not include any new land. So there would not have been additional open space requirements for that re-subdivision. It was essentially changing lot lines, and I know that there was open space involved, but you're going to have to draw for me how that comparison, how that decision relates to this one here.
So what we did in that particular application is, you're right, these were previously approved lots. It was actually, there were lot line revisions, so no new open space was required there. But we donated approximately 36 acres as additional open space during that application. The item that I'm referring to, Commissioner Williams, is Exhibit O. It's the minutes from the Planning Commission hearing on November 16, 2010. And it is on page 2. There's a colloquy between Mr. Gaishel, Mr. Volantic, and Mr. Torrance, wherein they explain, as per this 10-acre parcel, he said they will put the conservation easement on it now, but reserve the right to include it in future calculations. And so they were banking that land for future development. The conversation starts on the first page of the minutes, but it's clear as far back as 2011 that the developer was not, this wasn't a one and done sort of deal, that the developer was continuing to do this, and hence the reason for that. And if you look at Mr. Block's letter, or opinion, I should say, to the commission, which is my thumb is not quite back to full usage. Exhibit U, this is his memo, where he says, further, section 10-2-2 of the subdivision regulation says that if a parcel is subdivided in stages, the open space dedication attributable to the subdivision or a portion of that entire tract may be deferred until a later date. The critical language in this section is the reference to the subdivision being in stages and calculating open space based on the entire tract. And his conclusion is that you cannot require additional open space if they've met the requirements on that, even though they may be developing further land in the future.
Thank you for drawing my attention to those two exhibits. I may have some follow-up questions, particularly about Exhibit U, but I just want to circle back to something that we were just wrapping up on before you were able to call these out specifically, which was the 36 additional acres conveyed in January. Now, there was not any discussion at that meeting of banking those in the same way that the 10 acres was discussed in 2010. Was that your intent at the time, that those 36 acres be banked?
It's always been the intent that we've met and exceeded that, and we would be able to, based on Mr. Block's memo, to apply that to because there was further development. At the time, we didn't have a contract. We were negotiating for that, but we didn't. So the intent was, if we acquire it, yes, we want to be able to say, of those the 73% that we provided, we want to be able to use that or apply that for any existing land that we acquire to develop that's contiguous to this existing phase 4 subdivision. And, and again, as I said, there might be a time where we get to a point where we've used up that 73%, because if we add a certain amount of land to it, that percentage of open space is going to decrease based on the additional land.
Okay. I want to ask you one more clarifying question, because I just want to make sure that this is crystal clear to me moving forward. So I'm looking at the memo from Attorney Block, right? And it is talking about a total parcel that is being partially developed and open space set aside at that time. What I'm looking for clarification on is, I understand a phased development and he's talking about a 333 acre tract of land, and at this time, 198 acres are being developed, right? And the 39.45 acres are dedicated as open space. Out of the 330, you can then go back to those 39 acres, right? This is a newly acquired, not previously existing lot that you're adding to the subdivision. And I just want to make sure that I'm clear on this letter, because this, to me, looks like you can do exactly what you're saying when you start out with one big piece of land, not when you start out with pieces of land and then add and add.
Well, I would read it to say that we can, because they're talking about stages for starters. We don't know from this whether it was all under single ownership. That from his memorandum, it doesn't indicate that. But as I've indicated, in 2011, the applicant made clear to the commission when it was approved that it was intending to bank the open space for future development. And at that time, the only land that the applicant owned were the phases that had been approved at that point. So it was clear that the applicant was indicating intended to acquire more land, and it has acquired through the process more land, and has been incorporated into, as the memos from staff indicate, as a common development project. Because if we were to take your concern there, we would look at and say phase 1, we would have a separate amount of open space for phase 1, right? Phase 1 was a separate parcel under separate ownership. Then we acquire phase 2. Phase 2 would have its own open space requirement for that. And the history of this in terms of the approvals is that the open space that was acquired or provided in phase 1 met that for phase 2. Phase 3 comes along, we go even more, and the memo says now, in terms of the total phases that have been acquired and approved, they're at 73%. So it's clear that staff was, at the time, looking at this as a single entity. Even though we're acquiring land from different landowners, it's contiguous to, adjacent to, and it's the same theme of development.
But in most of those phases, you were adding additional open space. It's only the 10 acres that's specifically called out as banked.
Right.
So is the whole acreage banked, or just the 10 acres?
I'm saying that the 10 acres is banked, so we can apply that anywhere we want. Attorney Block's memo says that you could take that open space and move it to wherever you want, essentially, right? You don't have to, it's not finite. Once you say, I'm gonna donate the 5 acres over here, what Attorney Black says is actually, then you can undo those 5 acres and move the open space over to here, which is something we're not doing. We're simply saying, this is what we've given you for open space, we've got it. Worst case scenario, I would say is, if we bank those 10 acres, the open space requirement can come out of those 10 acres,
Mhm.
not out of this property.
Mm-hmm. Okay. Thank you.
All right, so I have a question. What is the status of Phase 4 right now? Is it still owned by your
English
client on English Harbor, or is it all built and sold?
No, there's still lots that are approved, and lots 26 through 28 are, I think, one of them is in the process of being built on. The others are approved but do not have houses on them, but they're owned by English Harbor, and I actually believe that one of them is owned by another individual.
Okay. I have another question. So there's the concept of property rights, and then you have the concept of like development rights. Okay, so in this case, you guys are claiming that you have development rights where you have property and banked, so to speak, right? So, you know, under property rights, you take a piece of property and you sell it, and then you don't have the right to that anymore. I guess my question is, at what time, what would terminate your development rights, which include banked open space?
When we finish the development.
Okay.
Let me put it this way, you wouldn't be able to take those 10 banked acres and go down to Niantic and say, hey, that 10 acres up there, you know, if that's what the concern is.
Any other questions about open space or anything else?
I have another question, but it's not about open space.
Mr. Scott, while we're on the topic, I do have a question, but I've been asked to recuse myself.
Yeah, I was going to wait till you were ready to speak, and then I was going to refer to the attorney representing the town and try to get a sense with whether we need to take a break and discuss this, or how to proceed. Because if you're being asked to recuse yourself, that to me means that we probably need some counsel as to whether, you know, what action is appropriate. So that would be a good segue into asking our town attorney or representative.
Don't give me too much of the title. So for the record, John Casey with the law firm of Robinson & Cole, we're special land use counsel to this commission and the Wetlands Commission on this application. I guess I'll start with the request to recuse Mr. Gaishel. It's not an issue I've looked into. I mean, so we all know that if it was a member of this commission who was being asked to recuse themselves, then it's up to the individual member to determine if they have you know, a conflict that requires them to recuse themselves. It's each member's individual decision. There's really no similar rule under zoning and fundamental fairness in zoning matters that apply to staff, because staff don't make decisions. So what I understand from Attorney Garrity is that his request isn't under the rules of fundamental fairness in zoning matters or planning matters, but it's under the town's ethics rules, which I am not familiar with. I don't know the procedure. I don't know if there needs to be a formal complaint. I don't even know if you have an ethics commission and how such a complaint would be handled. I don't think it would be this commission that would decide whether Mr. Gaishel has to be recused. So that's not much of an answer except to say, you know, there's an answer out there somewhere. But I'm pretty certain that this commission doesn't get to make that decision.
Okay. Thank you very much. That's very helpful. So with that, as a personal decision, I guess, and related to ethics, I think I'm not really in a position to tell you to recuse yourself, and I don't know. I'm understanding that we're not in a position to tell you.
Correct.
So with that, I'll let you do as you see fit. So.
Fair enough. So understanding that, if there was a conflict of interest, as it was immediately made aware to Mr. Garrity, I'm surprised I was not made aware of it earlier in the review process, because I would have been more than happy to allow the COG or another planner in the region review this application. That said, my question was in regard to the contiguousness of this particular parcel to the Nottingham Hills subdivision. Yes, it abuts the subdivision, but the land it abuts, 1 Kensington Drive, has already been conveyed out. So I guess there's a question there, is it separate then from the overall subdivision? That and there, I think, is the question that needs to be answered.
Mr. Chairman, I also have a few questions, maybe to Mr. Garrity, that might help, you know, to, I won't say get to the heart, but maybe shine some light on some things, because obviously whatever you do must conform with your subdivision regulations. This isn't a discretionary matter. If you meet the regulations, you meet the regulations. Obviously, there's some area of interpretation for those regulations, but if we could sort of get on the record, and I think it's in his letter, but maybe it'll just be helpful, you know, because there's a lot of information. So I guess, Attorney Garrity, if you could just let the commission know which section of the regulation you're proceeding under in regards to you know, your argument about open space.
This is why we had asked if we could get some understanding as to where folks are. And I'm not sure I understand the question, what section are we, this is a conventional subdivision.
Right, okay, actually, that was a preliminary question, and, right?
I did have a question on that as
Hold on,
well.
Then I'll turn it back to you.
Okay.
Well, we do want to come back
Well,
and
okay.
have all of your
Well, I
questions.
guess, my understanding is you're proceeding under 722, which says if a parcel or budding parcels under common ownership is subdivided in stages. I won't read it all. But is it your interpretation that when this applies to abutting parcels under common ownership, that it's any abutting parcels that come under common ownership in the future, and it's not just abutting parcels under common ownership at the start of the original subdivision?
It's anything that we would, abutting parcels that we would acquire, and I want to put the caveat in, I don't have the regulations right in front of me, so
Yep.
I would want, and I had asked, we could know what those issues were on that, so we would be prepared to respond, and I think I can respond that, you know, without looking at the regulations necessarily, that it would be any abutting parcel that we acquire that comes under our ownership, because certainly when when New England National and Niantic were approving us and banking the land, they were saying that it's being done for future development, and it would have been clear to everybody at the time that they didn't necessarily own all the abutting land.
Yeah, I don't mean to put you on the
No, that's
spot.
fine.
Like I said,
just
you know, I just, to the extent, I mean, the way I look at things can help the commission as it looks at things. So, and so that section, it provides that, so it's not too long, I'll read it. So if the parcel or budding parcels under common ownership is subdivided in stages, So it clearly allows subdivision of abutting parcels in stages. The open space dedication attributable to the subdivision of a portion of the entire tract may, at the commission's discretion, be deferred to a later date when more or all of the land remaining in the entire tract is subdivided. So that would seem to say that you could subdivide and then dedicate open space in the future, but it's your opinion that you can dedicate open space and bank it.
Correct.
Okay. But there's a provision that says, if approved by the commission, the following notation shall be placed on the approved map. And it's a quoted, it says, the open space dedication attributable to the land depicted on this map is hereby deferred to a later date when some or all of the remaining land is re-subdivided. At such a later date, the open space attributable to this subdivision will be combined with the open space dedications attributable to the remaining portions of the entire tract in a size and at a location determined by the commission in accordance with the requirements set forth in the subdivision regulations. So that's, do you know if that notation was placed on any of the maps?
I don't understand.
What?
No. And what section is that?
722, which I think is referred to. But
since I assume that the commission is not closing the hearing tonight, based on my conversations with Attorney Casey, I will provide that information.
Well, just as I told the chairman and I told Attorney Garrity, if the commission had specific questions either of me or of the applicant, we'd make those known tonight so that, either one of us would have time to submit something in writing for the other to consider. Because that was my understanding of Mr. Garrity's concerns. Coming into this is obviously a complex issue. It's nothing that we could resolve without having a meeting, so really, we got to get to this point and have this call if we just resolve it.
Thank you for that. All right. Any further questions, concerns? Michelle?
Yeah, I just wanted to review the one piece on the zoning regulations, and I don't see that this is indicated as a conservation design development, and I'm wondering why that's the case, as it exceeds the specified in section 23 of the zoning regulations, specifies that subdivisions of over 10 acres or over 4 lots shall be conservation design developments. And I note this as 14 acres and 8 lots. So I'm just wondering why that is.
Well, this is the first point in this process that we're hearing that was an issue, because what you would do is explain why you weren't doing a conservation subdivision, as opposed to that. We are doing a conventional subdivision because by pairing the driveways together and so forth, we're actually having less impact. So never brought up until I saw the memo tonight on that, but we can certainly address that. And I think that's what one of the issues we would have addressed had we gotten comments earlier. And I would note, just in response to Mr. Casey's point about the notation, I have to look at it and I'll confirm this, but my understanding is that the open space covenant actually reflected all of this, that it could be used, and that the notations are on the plans. But I will obviously pull those when I get back to my office and make sure that we have, because I know my letter's got a lot of information in it, separate sets that are readable in terms of the print on there, so we can present that to the commission.
Thank you.
So as far as outstanding items that are still remaining open regarding this application, Mr. Gaishel, do we have any other?
The only outstanding item is figuring out the open space issue.
Right.
Otherwise, under Mr. Garrity's proposal and the proposed plan, under that scenario, it complies. However, if it's determined that this is a separate piece and parcel and not contiguous for whatever reason, because there was land conveyed, well then, I would say it would have to comply with the regulations. But that is your discretion to exercise.
May I ask Mr. Gaishel a question, Mr. Chairman?
Feel free.
Just to say when, so I am clear, I think I understand what you said, but that if this isn't considered part of the phase subdivision, the only outstanding requirement would be dedication of open space, nothing else.
That's correct.
Okay, that's what I wanted to be clear on, so.
I don't see it that way because I still think that the reasoning for a standard subdivision versus conservation design development needs to be provided, which you said that you would.
Right.
But that would certainly be,
Which was partially addressed by, he indicated they combined driveways, right, to reduce runoff and things, which you couldn't necessarily maybe do for whatever reason under the CDD.
right, and that's fine, but I think we just need to
No,
have that on
understood.
record.
Anyone else have any things that they would like to have addressed before we
As
continue?
I said, the engineer and the surveyor are here, so if there's any questions you'd like to have, information, space, happy to answer.
The only other issue that would come up, separate from the open space, is the modifications that the Inland Wetland Agency made. Again, those were conditions. I did recall, and today, correct me if I'm wrong, but I do believe, and Tim May is here in the audience, he can speak to this, he indicated from a field observation, which was done, he said during the public hearing, that that section of land where they wanted this bioswale, the water wasn't running off of that and creating icing issues, the current conditions, so, and that these houses wouldn't create that condition. So based on, my review of the stormwater report and the town engineer's comments, that seems kind of consistent, like this was designed with knowing that the bioswale wasn't necessarily needed. Understanding, I think the commission's concern was they wanted it for just some remediation before the stormwater would hit the road. So I think Mr. May can speak to that and explain that drainage to you. Again, it's something, we'll have to get designed. I don't think it's problematic. They wanted it in front of the lot, so it wasn't actually being proposed on those lots. So it would be in what we would consider the road right away. We would have to probably draft some language and agreement with the landowner, and that the town could maybe maintain that swale. This was their primary concern, is that there's no proposed homeowners association, at least that hasn't been disclosed. So who's going to hold accountable the landowners for maintaining the rain gardens and the bioswales and the check dams associated with the driveways? So those items, all can be worked out. But they said, hey, if we can just put a bioswale in the right-of-way that the town maintains, that would alleviate many of their concerns with whether or not homeowners maintain their rain gardens.
So that was a condition of their
So
approval?
it's a condition of their approval.
Okay,
Yes.
so then that will be reflected on the plans.
I mean, eventually, yes. I mean, we're gonna, again, their engineer and the town engineer have the liberty to design this thing outside of, I guess, the scope of what's in front of you now.
Okay.
Just, Mr. Chairman, for the record, I think the record from last night will reflect that the condition, and I don't know, I'm sorry, Jerry, I didn't see this, that if the bioswales are needed, or would be added if they were needed in the opinion of the town engineer. And I don't think that's reflected on the approval.
Approval.
Yeah.
All right, we can,
That's
well,
important, that's an
we still have
important
to
point.
generate the permit
Yeah.
itself.
Yeah. Because that
We'll
was
just
the
get a
report
report
of
out,
the permit. Yeah.
Okay, so,
I have a question. I think I need to direct this to Mr. Casey about the subdivision regulation that you brought up, 722. The language says, at such later date, the open space attributable to this subdivision will be combined with the open space dedication attributable to the remaining portions of the entire tract in a size and location determined by the commission in accordance with the requirements set forth in the subdivision regulations. Does that mean that this panel is tasked with finding the spots and the size that we want, or that would be suitable in the subdivision regulations, and that basically they have banked the land, but we tell them how to spend it?
I think in a perfect world, and I know this development and this property has a long, complex history with the town and with its approvals over time, but you know, this is a very kind of simplistic regulation, you know, that is, I think, designed to provide flexibility for both the commission and the developer. When, you know, reasonably so, a development has to be done in stages and provides not just, you know, for the situation where someone has, you know, 50 acres in one tract and they want to do it in, you know, clusters of 5 homes, 5 more, 5 more, 5 more. And then, you know, at the end of the day, at the end of the development, the open space would be set. You know, it does provide that if you have abutting parcels under, you know, abutting parcels under common ownership, then you can do those in phases as well. I mean, I think it's always this commission's prerogative to determine where the open space is, or accept what's presented by the, you know, by the applicant if it meets your regulations. I don't think you can go outside the 4 corners of the regulations and say, you know, no, we want, you know, you're offering us, say, 50% of it being water. Your regulations allow 50% to be water, but, you know, we really want more dry land. You can't do something outside the regulations. But I think in general, it's, you know, if it's proposed and it meets your regulations, typically, in my experience, that's an open space that's accepted by the commission. You can't take like the 10 prime building lots and say, you know, we want those, we'll give you the, you know, the land up in there.
You're also alluding to the fact that the long and kind of organic growth of this particular development is overcomplicated for the simplistic nature of the regulation?
I think the regulation was designed for, you know, didn't foresee all the possible permutations that it could be applied to. That's
Thank you. That's my question.
which is not unusual when it comes to regulations. So.
All right. So I think we'll maybe table discussion and
Well, I think it's important to note that we have 35 days from the time the wetland agency acts to render a decision on this application.
Because you were on hold while the statute allows you to place your decision on hold for consideration and decision while you're waiting for the wetlands approval. Now that that's been issued, you have 35 days from the issuance of it.
Which would be January 18th, 2022.
okay, what day is that? Is that
It's
a
the day after Martin Luther King Day. It's a Tuesday.
Tuesday? Okay, so that would end up being a special meeting if we are able to do that.
That's 35 days from today's date. My suggestion would be go to the 11th.
Okay.
There is a conflict in this room on the 25th.
January 11th, which is also a Tuesday. So I'm thinking we should have a meeting. Is everybody able to make a January 11th meeting?
Yeah.
Yes.
Sure, yeah.
And do we have a good accounting of the topics we want to have addressed while for review?
I guess I would just ask Mr. Chairman that if you want something specific from me, like a memo or anything applicant knows what to expect.
Okay.
Or if you feel like you just want to hear from the applicant, or
Right, I feel like we need to come up with a list of topics for opinions on or clarification so that it's well known to everybody what our concerns are. So, okay, with that, do we have any more questions for the applicant?
I do not.
My part, Mr. Chairman, since it seems as if the engineering issues, surveying issues and so forth have been addressed, I just don't want to have to drag my professionals out for another hearing. Just be clear that this is really going to be the open space issue and not.
So far as I understand it, it's coming down to open space.
I just think it would be helpful if in that time that applicant's engineer speak to the town engineer about the swales.
Sure.
And determine what, if anything, needs to go there in the opinion of the town engineer to comply with the.
Yeah, I guess the concern would be if installing any of those swales, if they were necessary, does it impact the layout of the subdivision? And I will just say, I caution the agents, the wetland agency, that the location of the septic systems, which are in the front yards, have to have a separation distance from any rain garden or swale that's gonna be, down gradient. So I think it's like 25 feet, so that's a big distance, and we may not be able to achieve it. But as I was saying, again, I believe field observations indicated there was no issue with runoff on that portion of the property. I think he can speak to that if you want to verify that. He's nodding his head, so I believe that's a yes.
Yeah, I think,
And if we could have that conversation, maybe even report back to the wetlands agency. I know they're not gonna meet before this special meeting, but maybe at least have something
To reply to them.
to reply.
Yeah.
We can certainly have, Mr. May will certainly reach out to Mr. Close and discuss that issue with him.
yes, that would be good. Thank you.
All right, thank you.
So,
Thank
Thank
you
you.
very much.
Thank you.
So you're going to generate this list?
yeah, I think we should take probably a minute and generate a quick list of our items that we want to have clarification for and get that out as soon as possible. So, has everyone been taking reasonable notes?
Yeah.
Okay.
So I think, on Michelle's comment there about the CDD versus the conventional, and it was indicated they were going to speak to that. Obviously, I would start there. There's question number one, because if you're going one way or the other, right, that's going to basically dictate how you put your subdivision together, whether it's conventional or whether it's by the CDD. So I think the first step is knowing what supports that. The conventional is a better design than the CDD, and therefore we should consider that.
As
And then-
related to the
Correct.
regulations.
And then if it's determined that the conventional is the way to go, and it doesn't need to fall into this section 23 CDD, well then, the open space argument that he's making is sufficient. But if he has to go CDD, then he needs to provide open space.
Yeah.
Because it's a different type of development than the previous phases, or?
Correct, and again, I would note that this is a subdivision and not a re-subdivision,
Yep.
right? All the other phases, I don't know, we have the information here, we can look to see if they were subdivisions or re-subdivisions. I think they might have been a mix of both. But at least the initial subdivision was the subdivision, the tract division of land into 3 or more pieces, right? Anything subsequent to that is a re-subdivision, so if you're adding land, it would be a re-subdivision,
Especially if you're considering a phase of an existing.
existing subdivision. So the only ironic thing here is that it's a subdivision and not a re-subdivision.
problem is, like you
Food for
said,
thought.
yeah, trying to determine if the, you know, do these rules apply from something that's that old or whatever, you know? It's,
I just want to note for the record that the applicant has left the room while we're still discussing the matter.
That's an
Yep.
important
Important to
point.
note for the record.
It is important.
Continuing on our list, I would love any applicable case study that would relate to our section 722.
Yeah.
Legal decisions.
Yes. Need to
Right,
get my
because-
law jargon in better shape.
Because my question about when a subdivision starts and, or not, yeah, when a planned subdivision, is that when it starts and when it stops? Like what constitutes
A phase.
the end of a phase or the beginning of a phase
that's what
or
I was thinking, just like-
The end of the project.
the end of a project?
Because based on the answer I heard, it was indefinite.
Correct.
That's what-
When they
that's
stop
what
developing,
confused me.
well, when's that?
That,
When I'm
that's
done.
clarification.
And we can look at that. We talked about that, Mr. Gaishel and I, what research to do, but once I heard from the chairman that we were gonna have this discussion here, I didn't wanna keep using the phrase out over my skis on anything, so, no, but that's, yeah, I think that's reasonable. Looking into my crystal ball, I'm gonna say all those cases will probably depend on the specific language that a court looked at.
Mhm.
So whether we come across similar language, I mean, we'll probably at least be able to, sort of extract something from the reasoning.
So is that something where
We-
you're going to be able to look at other cases that are similar nature where they were contiguous or not contiguous, phased?
Yeah.
I don't, good luck, I mean, how do you research that?
Are you
We
referring to the
probably search
Kensington?
subdivision cases. I mean, you can do word searches, so we'll probably look
You-
at
you
cases.
just- The idea is just to look for some case law that's out there that helps support us making a decision one way or the
Yeah.
other.
You're not specifically speaking of this one. You're talking of other stuff that happened before
Yeah,
this.
but
Yeah.
other- yeah.
So
it's-
I was
other
curious,
outcomes,
you
yeah.
brought up the Kensington property, which,
Well, the only, I mean, again, looking at the subject parcel, it's adjacent to the Nottingham Hill subdivision. There's no doubt about that, and I stand corrected. However, the land it's adjacent to has since been conveyed to private landowners.
Yeah, that's nice.
It's now separate from,
It was purchased
So
after.
it's not,
Oh, okay.
then it's not contiguous.
When does that abutting land in common ownership
become contiguous.
provision apply?
Yes.
Okay.
Ever,
That's-
like abutting, can
Someone
you have a
keep
subdivision
buying
'Cause
it.
years ago and now you own it and now you say it's a new subdivision?
That's-
And
Or is it, one parcel or abutting land at the time?
Just, so we're looking to
clarification on that.
clarify, just because you developed something doesn't mean you own it forever and can count it as abutting once you've sold it
Purchasing
off.
After,
they're betting from,
That's the crux of it, yeah. Can you keep, as, applicant's attorney, say, well, we could, as long as there's new abutting land, that provision would apply.
Yeah, they go on
But
forever.
as soon as it comes into common ownership with the now owner of the subdivision.
but it's
Right.
not it's not abutting any land that's currently owned by English Harbor.
Because the lots.
It just was at one time.
And the
It
lots.
was owned by its predecessor who started
Right.
the subdivision.
Which,
So how long does that thread stay connected?
that,
Yeah.
my
that,
opinion would,
that's,
my-
there's
I would say,
another,
my opinion, that thread only stays connected the moment he conveys the land to another landowner, he no longer has control.
that's, yeah, I'm saying, because you keep purchasing, and the land you purchased above that, keeps going, that you buy that land and another land, it keeps moving forward all the time, you never, if there's 300 acres, you keep going.
And if you always go back to the boundaries of the original parcel that was subdivided.
Yeah.
Regardless of current ownership.
but
Right.
that's what my
Clarification.
point that I was trying to make about property ownership versus developer rights. That's,
Yeah.
They might have some residual interest in the lots, like that they maintain or, whatever covenants apply to the old subdivision lots that are now in private hands. That's the only interest of having those lots.
And
The driveways are maintained.
again, and the remaining lots are at the end of a cul-de-sac on the opposite side of the Nottingham, the street of Upper Kensington. That's the land that English Harbor retains.
Mhm.
So that land doesn't abut this parcel
Right, and you can't access this parcel from those roads.
without going through the 16 Mostaway, which is the town-owned parcel. So how do you, I guess my interpretation is because these portions of land, these parcels have been conveyed to other entities and it's no longer contiguous, how do you make the argument that it's contiguous ownership? And the question is, do you need contiguous ownership? Or does it just need to be contiguous to a piece of land?
There's a significant legal, that's a
So,
question that
If I buy land.
we don't know what that means.
Well, and I think, I'll do the research and I can make suggestions, but if every land use attorney tells their commissions, at the end of the day, you get to interpret your regulations.
Some information would be good. Whatever you come
Not
up
that we
with.
passed the buck.
So,
Very diplomatic.
Whatever you come up with.
so then the next item that I have on my list would be providing some kind of confirmation of the banking, including what regulations allow for that specifically, and for documentation of those banked pieces of property, either through a map or an written agreement, like somewhere where it like says these are, and to that point, what weight do meeting minutes carry in that regard? There was a lot of emphasis and talk regarding the meeting minutes from 2010,
Right.
11,
and
2010,
the context of the meeting minutes is not always the full picture, and is that a binding?
No, I mean, there's nothing binding in here. What's binding in there? Okay,
Well-
they banked this 10-acre piece, they'll put a,
Yeah, that's from
you can put a
2010,
conservation on a 10-acre piece and bank it for future subdivision of another phase, which would theoretically be some of the land that was originally part of the initial tract.
That's
And that's why that provision 722 requires the note on the plans, because, your comments or comment, even in a transcript of the record, if we record any one member's comment or something in the minutes, that's not the, the formal decision of the commission as to how you're doing something. It's just one person's comment, especially if it's a comment by an applicant or the attorney or the planner. Those are just comments that happen to make it into the thing. That's why if there's anything in that, to mean that particular regulation, but that's why it has a very specific requirement that the note has to go on the plans that, okay, identifying this open space, it's being banked. And that's why you want to see it, because otherwise you somewhat ended up in the situation we have.
Yeah.
Mr.
So,
King?
I'm sorry, this is a follow-up question to that exact note. Further to that, though, regarding the timeline, action on that particular item has not been taken in 10 years. And I'm curious as to if this was an approved subdivision application that we were re-looking at now after 10 years, it would have expired. Yes?
No.
Is that?
That's an interesting
So
point.
is this note in the minutes still even, would it have, is it still even applicable? Even if it does count, more than 10 years have passed and no action has been taken on it. That is a question, not a suggestion. I just want to make that abundantly clear.
To piggyback on what you said, the regulations were approved in 2011, so I don't know if that even changes this. Because if this
How
happened,
can you rely on a regulation that didn't exist at the time?
Well-
You'd have to may have to look at old regulations.
I'm sorry, could you repeat that? What you said the regulation didn't exist?
Yeah, it says, well, the subdivision regulations were effective February 1st, 2011.
Yeah.
Was that in the minutes or
I'm
No,
just looking on the
On the
website.
website.
2011? Oh,
So
you're talking about the 20
did
2010.
722 exist prior to 2011?
That was revised in 2011, I guess.
Um, I think it did. But that said, we had cluster regulations in the zoning regs. We didn't have the conservation development design regs. So we since then eliminated the cluster regulations and adopted these conservation development design regs, section 23 in the zoning code, and basically our entire subdivision regulations. So there's that question. We have a new set of regs. I mean, it's a conventional subdivision, so we're applying these, not cluster regs.
Well, you're trying to apply old regulations.
Nottingham Hills subdivision was a cluster subdivision, if I understood that correctly. So, you know, but I guess that's neither here nor there, because they're making the argument that what they're doing is more environmentally friendly than something else. So,
It's simpler at the end of the day if they can just get the conventional subdivision and
right.
provide the open space. It would only have to be the open space for the 8 lots.
Correct.
Right,
Not
but
the overall, because the remaining piece is, they're keeping an entire piece, 46 acres or so, plus or minus. And that's part of the original tract.
Yeah, I don't know how that applies.
So I would say that would be eligible for re-subdivision. If they wanted to phase the subdivision, that could be phase 2. But
They could identify that as phase 2
right
now, and they could
or you put,
hold
you
off,
know,
bank, hold off. They'd only need to bank or dedicate the open space for these
8 lots.
8 lots now.
That makes sense to me.
The 4 acres,
Yeah, it's four, he said
4.2.
4.6.
right, yeah.
So I think, you know, it's really just a matter of, I mean, everything is in place if we look at it and we're saying, yeah, what they did was, you know, correct, and the proposal works the way they're proposing, and they're right somehow. I don't know. I tend to, I have my opinion. I'll keep it to myself. But we'll see. And
Yeah, I just don't see how the old stuff applies to this newer stuff, that's all.
that's,
Something that's
my-
almost 10 years old.
More than.
That's a question I never really contemplated. So
Yeah, I just don't see how that
w-
applies.
at what point does that subdivision expire? If it's 10 years from the inception, or 10 years from the last phase, or 10 years
Well,
from,
Here's what I could add. Let's take a look at what we did do as a commission. We did expire the Darrow's Ridge subdivision, and we called the bond and we completed the road. We physically made a motion. Now, we look at the Orchard subdivision. They're still under construction. It's been well over 10 years. We have not taken a motion to expire the subdivision. Now, we could, but there have been consistently developing and
Yeah.
banging hammers.
Right.
Yeah.
So we as a commission, or I should say separate, you as a commission, or the commission, decided that that was acceptable to allow that condition to continue
Because you're still building.
because they were still working and progressing. Whereas all work has stopped. We, in a matter of fact, in the Nottingham Hills subdivision, we called the bond there too. You can only guess the developer. And both Darrow's and Nottingham were the same. We do have some public improvements that are still outstanding to be installed on the Nottingham Hills subdivision, particularly the streetlights. I'm not sure why. I'll look into that for you. I believe when we did call the bond, there was money allocated for it, so I'm not sure why they have not yet gone in.
all right. So, how many things do we have on our list? 4?
I have 4, but the 4th one has a lot of sub-bullets.
Okay, do we have a way to convey that, like,
Well, it should be, obviously, if you can repeat them now so they're clear in the minutes.
yeah, we
Yeah,
want them
do
in
you
the
want me to
minutes.
do that?
Yeah, just say it again.
Okay.
Yeah, because there's no question about where the ideas came from.
So the first thing is on the onus is on the developer, I believe, is can we require a CDD here, and why is this not a CDD, right?
And what regulations?
Right.
say-
So that's zoning regulations, section 23. Currently, it is not conforming to that section of the zoning. I believe it's at our discretion, but the case has not been made to us why it should be a standard subdivision and not a CDD. Two, I think Attorney Casey's going to provide us some clarification on other examples we can look to in our own interpretation of subdivision regulations, section 7-2-2. The third is we're looking for some clarification, and again, possibly other examples to look to determine whether or not this piece actually is contiguous land now that it abuts a piece of property that is no longer owned by the developer. So just because the developer developed that parcel at 1 Kensington, does this mean that this land is contiguous to the original parcel? Then the fourth thing was providing confirmation in the record of the banking of open space for the future. So we're looking for what documentation exists either through map, written agreement. We've seen that it's reflected in the minutes, but we do not know how that holds up. And in addition to wanting some detail on the documentation there, we're looking for some clarification on whether or not it would expire, as it's been more than 10 years with no further action on it. As well, section 722 is in our current subdivision regulations, which were adopted February 2011, following the discussion of the 10 acres of banked open space. Did 722 exist in its current form at that time? Was that consistent at the time? And then I think separately, there was some discussion about the bond being called on Nottingham. Does that indicate completion of the subdivision?
And/or
That's a lot.
termination.
That's a good point.
I mean, termination, expiration, we go back and forth with these terms. I'm not sure. They kind of mean the same to me, but I think in the legal world, they're different. I do know that. And I know we wrote expired on those Mylars. So that may mean it terminated then. And I guess at that point, maybe did that terminate any rights? Development, I don't know.
That's an
Find out.
important thing to find out.
Yeah, so I think it was number 5 you said, would the banking expire? So I think it's kind of as it relates to the expiration of the subdivision, right?
Right.
Correct.
Or even further, is there a legal definition we should know about what a phase is in consideration of when a development is finished? Like, is there a specific case law that points to?
Usually, typically, there are public improvements. And when all the public improvements are completed, the town accepts the road and the development's over.
Yeah.
And they begin the next phase. If there was an end of the cul-de-sac type of a thing, or it just stops.
And the houses may not be built, but all the lots are created and
Right. The
separate.
monuments are set.
Yep.
The roadway is paved. Curbs are in, street lights are up, street trees are, it's all finished, and you could not have any houses.
Yeah. Okay. Makes sense. You can sell
I don't know anyone who does that, but.
That's how it
Okay.
is.
So that looks like a good,
Houses built at
Right.
Looks like
A
some
good
homework.
list.
Yeah, you have your work cut
Yeah.
out for you, sir.
A good list. Are we happy with that?
Yeah.
Okay.
I think so, yes.
Thank you. That was hard to get through. I appreciate you doing that.
And I guess, I don't know, probably for my own, I guess, benefit, I'll pursue with Mr. Siri the ethical issue, and if I should step down from any review, I'll be more than happy to.
I think the important thing is to get it addressed directly and get an opinion.
My question is, should it be you to bring this forward?
I'm not voting on it.
No, he's talking about the ethical,
Yeah, like,
ethical.
in the education world, I'm a teacher, and if a professional was called into question some behavior, that person would not be the one to pursue, exploring these options.
Well, I'm not going to incriminate myself, but I mean, I did express interest in the land. I do not have the financial wherewithal or capability at this time in my life to acquire a parcel of land for 1.8 million or 3 million or whatever that Mr. Dravick is offering. And I don't know if Mr. Dravick is Mr. Gary's applicant. I believe English Harbor Association is his applicant. So depending on what happens, I don't know. So I haven't pursued Mr. Dravick, but like I said, I don't have the wherewithal to do that.
I did not mean to sound like I was accusing you of anything. I'm just saying that if this is to go forward in any kind of other legal apparatus, would it be, maybe this is a better question directed to Mr. Casey, that it be someone other than Mr. Gaishel approaching Kevin Siri about whether or not this ethics commission should weigh in on his
Well,
activity?
I think he can inquire. I don't know if the rules, as I said, if the rules
Yeah.
require, say, a formal complaint, and if no formal complaint is forthcoming, then I don't think there's any action that the town has to take. So I think
Okay.
just based on the applicant's attorney's statements tonight, it's prudent to bring it up with your superior and make sure you understand the rules and what's required.
Okay.
Yeah, that's basically what I'm doing. It's just letting Mr. Siri
Okay,
know.
Okay, so I think that tables the discussion on this item until January 11th.
Do we need to vote on that January 11th meeting?
Not that I want to belabor it, but if that be the case, any large tract of land in town that I may express interest in purchasing, which I'm entitled to do, would I then have a conflict of interest if someone else was to subdivide it? It's like it almost makes you feel like you can't buy land.
So,
So,
not to cut the discussion off, but we're not in a position to tell you that you have to recuse yourself. So I feel like that should be the end of our discussion.
Agreed.
very well.
Do we need to vote to set the meeting on the 11th?
We need calendar.
I'll take a motion. If you want to make a motion, we can just do the vote.
I make a motion that we schedule a special meeting of the Planning Commission on January 11th at 7
Thank
o'clock.
you, Jason. Second,
Second.
Tom and Rich, thank you. Discussion, all in favor, aye?
Aye.
Oppose, abstain. Let the record show we're going to have a meeting on January 11th at 7 o'clock, which will be a special meeting. Moving on to zoning referrals, there's none. Municipal referrals, there's none. Old business, we have an affordable housing plan update.
I do not have an update for you. I
Um,
apologize.
No, that's fine. And which brings us to new business of the meeting calendar. Has everyone had a chance to look at it?
Yes,
What-
I had a question.
Okay, yep.
November 8th this year is Election Day, and I don't think there's anything that stops our commission from meeting on Election Day, but I was just curious what members thought about that.
We can
It's
make
moving.
whatever changes we want to make to this. So if you feel like you want to not be here on Election Day, we can change it right now. If
Yeah.
there's, you want to change?
Usually you don't have it on,
Yeah, normally we
usually
don't.
Let's-
postpone.
let's-
Move it to the,
because the schools are all, using all the things and you gotta get the vote.
Yeah, we
For
don't,
me, it's,
we don't
I
want to
gotta
do
work
that.
and then I gotta get to
Well,
vote too. so
I
it's like,
actually,
yeah,
I have
possible.
I don't know, my calendar's telling me November 1st is election.
So November 1st is the
Tuesday of the
first
month?
Tuesday of
First
November.
Tuesday of November,
Right, but my
But
phone says it was November 8th, and I don't
and I
question
have
the wisdom
election
of
down
Apple.
there too.
So,
It's the
Yeah.
first
Why
Tuesday
is
after
it
the
showing
first
up on
Monday.
both spots?
Wow, Sue, thank you.
All right,
So
well,
what's-
we could shoot for the 15th and be safe.
Great.
okay, let's change that meeting date to the 15th. Any other changes to the agenda or to the schedule? Do I hear a motion to approve the amended meeting schedule for 2022?
So moved.
Thank you, Michelle. Do I hear a second?
Second that
Second.
motion.
Nicole Davison, thank you.
Sure.
Any discussion? All in favor, say aye.
Aye.
Opposed, abstain. Let the record show 600 that we are accepting the amended meeting schedule, which brings us to election of officers. I don't know that we can do that without an,
You can turn the meeting over to me, I can run it for the
Okay.
chair, and then, because there's no ex officio,
oh,
right,
Right.
we
Okay.
normally would do it. I can
Right.
do it on their behalf, and
that sounds reasonable to me, so as such.
Prior to doing that,
I have
can
a
I?
question.
Oh, go ahead.
Do we have to address the release of the bond? Or,
Oh, yeah, we did add that as new
No.
business,
so
didn't we?
that'll, I mean, we're at I mean, if you want to take it ahead of the election of officers, but you're out of election, so we're just taking it in order.
Okay,
Yes, thank you.
I did want to just, before we turn this over, under election of officers, I believe that there's an error on the agenda. When we updated our bylaws, we indicated that this commission would have a chair, a vice chair, and a secretary. I have pulled up the revision as of March 8, 2021, but I need, I'm relying on the memory and clarification of others in this room. I do not know when we adopted these. I'm looking at a red line version.
I think we did actually adopt them. I don't know exactly when. We did.
So I just want to reflect, I believe we adopted them too, and I didn't have time to pull up the minutes from that date. I had a copy of our revisions, but I believe that we now, our bylaws reflect the 3 officers. I'm not sure that that means we have to fill them all, but we did declare that this would be our governance,
I
so.
think we should follow the bylaws,
Agreed.
and we did adopt
So
them, right?
you
I
wanna
don't think
add-
that, we need to make an agenda change to add
you-
vice chair to the
You would need,
officers.
someone can make a motion, and then you need
Do I
a
hear a
two-thirds
motion to
vote
add
to add
vice
the 3rd
chair
officer.
as number
3.5.
1.5?
Good thinking.
Thank you, Jason. Do I hear a second?
Second.
Thank you, Rich. Discussion? All in favor, say aye.
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 Opposed, abstain? Okay, let the record show we are adding item 1.5 under new business, item B, as vice chair. So with that, I am going to turn the chair over to Mr. Gaishel.
Okay. Welcome, congratulations all who got elected. First, I'll start with, do I hear any nominations for the position of chair?
I'd like to make a nomination. I'd like to nominate Michelle Williams as chairperson.
Do I hear any other nominations for chair? Going once, going twice? Okay. Is there no other nominations for chair? All in favor of electing Ms. Williams as the chair of the Planning Commission 2022?
Aye.
Aye.
Unanimous. Abstain. Discussion. All right.
Okay,
Hand it
so-
over to you, Ms. Williams.
Well, thank you, and thank you to all of you. It's been a real pleasure serving with you all, and I look forward to continuing. Thank you. Do I hear a nomination for vice chair? I would like to nominate Kirk Scott, vice chair.
Thank you.
Any other nominations? Any other nominations? I think I have to say it 3 times. Any other nominations? Hearing none. All in favor of Kirk Scott for vice chair, please say aye.
Aye.
Unanimous. We have it.
I abstained.
You abstained.
I did.
Okay.
Aye.
You want to vote for yourself?
You don't want to vote for yourself?
It doesn't matter.
Yeah.
Well, thank you, Kirk, for your
Thank you.
continued
Yeah, and thank
leadership
you.
service here.
Yeah.
And finally, do I hear any nominations for the position of Secretary of the Planning Commission?
I would like to nominate Rich Gordon.
Do I hear any other nominations? Are there any other nominations? Are there any other nominations? Hearing none. All in favor of Rich Gordon for Planning Commission Secretary, please say aye.
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 Any opposed? Any abstain? I missed that last abstention. All right, looks like we have a unanimous vote for Secretary. And thank you, Rich.
Madam Chair, before we move off of this, I don't know where this would fit in at all, but I was wondering what the process would be for initiating a more inclusive name for your position now, rather than calling chairman.
I believe we would revise the bylaws
Yeah.
to chair.
It should be chairperson, right?
Yeah, or
Is
just
that the correct?
chair.
Or chair?
Chair, and then maybe, you would refer to them as chairwoman, chairman, whether they're the gender, chairperson might be.
Right, but as a matter of propriety, including it in some sort of bylaws, I was just wondering what the procedure would be.
That
Going
brings up
forward.
kind of a side discussion. I know Kirk and I had talked previously about, as we kick off the new year, maybe something to look at is our bylaws and what, if anything, needs to be revised. So I can email that out to y'all, and maybe that's something we address. Yeah.
I would like that.
Great, thank you, good point. Also, before we move off of this section, I do feel like it's important to acknowledge, I do not believe we have met since the passing of one of our former members, Peter Lynch.
yeah.
And I know that all of us have worked with him in some capacity, whether as a member of this commission or outside of this commission, and I know that he is nearly directly responsible for 4 of us sitting here today and for encouraging us to be involved in this commission. So I just want to take a moment to acknowledge Peter and his contributions to this commission in this town, and to just publicly say that we thank him and we're thinking of his family and their loss.
Well said.
Well said.
With that, the last item of new business is the bond release for the Pizzaglia properties at 249 Upper Patagonia Road and 41 Scott Road. Mr. Gaishel, do you have some background or comments on this one?
I'm supposed to. What I can tell you is that the certificate of occupancies on both of these properties have been issued. Both sites are lawned, seeded, stabilized. So in regards to the release of the bond, they're for erosion sedimentation controls, are in relatively small amounts. You can see, I think one's 4,000 and the other is 1,500. So I'm comfortable with releasing the bond as the work has been completed, the sites are stable, and not a mess.
Okay.
This is more an administrative matter, as it's been sitting on our desk for quite some time, since October. The site's been finished, I think, for over almost a year now. So,
Does anyone want to put out a motion to this end? It looks like we do have something we can reference in a memo, should anyone wish to do that. It looks like it's this one, second page. Oh, I'm sorry. That's old. That's the original approval. I thought it said 2021, it said 2020. So I think we can just take a motion, if anyone would like to move to approve the release of the bonds for 249 Upper Patagonia Road and 41 Scott Road.
So moved.
Do I hear a second?
Second.
Thank you, Ms. Davidson. All in favor?
Aye.
Aye. Any opposed? Any abstain? All right. 600.
Madam Chair, again, I don't know where this would fit, but I had a question as to why they were both bonded through Bank of America. Is that standard practice in the municipal best practices?
Whether it's the developer goes to the bank, and if he has a relationship with that bank, they can provide him a surety bond, a cashier's check, a letter of credit. We have to, as a town, accept all the forms allowed in the statute, which unfortunately still includes the passbook savings account. We were trying to push developers and applicants into only posting cash. We did that for a while until the statute changed and then just demanded that towns have to accept all the forms. So what we tend to get now, these are small amounts. They were basically cash. If they were larger, we tend to get the surety bonds, and those are a little harder to track because when the premiums aren't paid, we don't necessarily get notified.
I was
So-
curious,
That's not good either.
is there a way to steer people towards smaller community-based partners, credit unions, that sort of thing?
Typically, what is interesting is that these are Bank of America. Usually it's like Dime or Rockville or one of these smaller local, CPCU, Charter Oak. Usually they tend to do a lot of loans, but anyway, that's kind of what we see. And I guess Mr. Pizzali just chose Bank of America.
And forgive me for asking if it would be out of order to suggest that people, if they bring bonds to this commission, seek out one of those smaller banks first, for the sake of local economic vitality.
I think it's just a suggestion. It's not a requirement. They don't have to. As long as they know they don't have to, they can pick and choose their own. But we can always recommend they try to
Support local.
shop local.
Yes. Thank you, Madam Chair.
Very good. Hearing no other business, would anyone like to make a movement to adjourn?
So moved.
Thank you, Mr. Scott. Any seconds?
Second.
Thank you, Mr. Gordon. All in favor? Aye.
Aye.
Any opposed? Any abstain? All right, we have it. Thank you.